So when we have a case in federal court, what we look at is whether the judge made an error in how they made the decision. So, for example, there might be a certain type of evidence or a certain piece of evidence that the judge overlooked, or maybe the judge didn't completely consider that evidence. There might be a medical opinion in the record, and we look at, did the judge follow all the steps that they're required to follow in deciding how much weight, how they need to approach that medical opinion. So we will look through the facts of the person's medical record, how Social Security approached the record, how the judge approached it. Did the judge consider? Maybe sometimes the judge will miss a record or not consider the record completely. Or sometimes they'll mistake. They think maybe an opinion is from a doctor that this person only saw one time, when in fact it was a doctor who you've seen several times and knows you well. So those are the types of things that we look at in considering whether the judge made a mistake in how they made the decision that the person isn't disabled. When you're in federal court, we write briefs. So we present our brief, we present our arguments, why we think the judge made a mistake, and then Social Security, through the federal court system, has a chance on paper to respond to us. So unlike at an administrative hearing when you're in front of a judge, the federal court is just briefing on paper, and you yourself won't see the judge at federal court. So when you are at federal court, and we're arguing that the judge made a mistake, sometimes Social Security actually will agree with us and say, okay, we agree the judge made a mistake. Sometimes we go through some more appeals, we go through some more brief writing, and then the judge looks at both arguments, our arguments, and Social Security's arguments, and the judge will say, okay, yes, we agree the administrative law judge made a mistake. So if we win at federal court, what that means for you is that your case, your claim will go back in front of administrative law judge, and you will have another in-person hearing with the administrative law judge for the judge to take another look. That means the judge's denial, the judge's decision saying that you don't qualify for benefits is put aside, and the administrative law judge has to look at your case again, you get a new hearing.